Welcome, everyone. We're excited to invite you to our third JOM mini conference session, a virtual webinar session where we'll be talking about dispute resolution and breaking the cone of silence. I'm one of the moderators, along with my co-editor-in-chief at the Journal of Operations Management, Suzanne de Treville, and also John Gray, who is the department editor in our public policy department. I'm going to hand over to Suzanne, who's been a prime instigator in this event and has several very interesting panelists to introduce.
Great, thank you. So we started with our interest in dispute resolution with a special issue on the sharing economy a while back, because it seemed to us that dispute resolution was really important. And a couple of concerns immediately came to the top as we started to look at this. One was that when we looked at dispute resolution, what we saw was arbitration, and that arbitration was mandatory. So dispute resolution equaled arbitration. And the American Arbitration Association puts a lot of data up on its website, and you look at that data as you're kind of thinking about arbitration, and what you see is that there are a lot of dispositions that are quote unquote administrative. If we look at self-represented or pro se consumer cases that had a disposition in 2021, 35% of those were administrative dispositions, and those are not defined. So you go, scritch, scritch, what is going on here? And who are, some of the companies that have many administrative dispositions? Well, a lot of telecommunications companies, but you also have PayPal. PayPal is one of the top couple. Airbnb is in the top 5. And then you have banks like Wells Fargo Bank. So we thought, we would like to understand this better. So we're from operations management, and so we do systems thinking. And then we throw in our good old-fashioned idea of Gemba, go to where things are happening and observe it. And so we said, let's go look at an arbitration case. One presented itself. The claimant opened the case at the American Arbitration Association, paid a fee of $200, and immediately heard back, after a fair amount of effort to get there, that the respondent's lawyers preferred to have this matter resolved in small claims court, and that this would result in an administrative disposition. So the first case that we looked at turned out to be one of these mysterious administrative dispositions. I said, that's interesting. Well, where did this come from? It turns out that there is an administrative rule. Okay, so I do standard operating procedures. So this is, as far as I'm concerned, a standard operating procedure. It dates back to 2014. And when you have one of the suggested interpretations of this rule, it means that the respondent can say, no, thank you, I'd rather not go to arbitration today, even though that same respondent had drafted a mandatory arbitration clause, which is why the claimant went to arbitration in the first place. This was a bit surprising. So the claimant protested that, by the way, we've got binding arbitration clause here. We have the right to arbitration. The American Arbitration Association, here we are, rule that dates back to 2014 said, this is an arbitrability dispute that must be resolved by an arbitrator. So they named an arbitrator. The arbitrator said, the claimant has not demonstrated the right to mandatory arbitration, dismissed the case, and the AAA kept the $200. Well, I've done a lot of N equals 1s in my life. This has got to be the most exciting. So what do you do when you have a sense that something might be a bit of concern, and you look at one case and you go, that was of concern? You bring together experts that cover all the various viewpoints. So that's what today's webinar is about. So we want to begin by establishing our understanding of the economic consequences of trust in dispute resolution, and that will be Akhil Bhardwaj. And then we need to understand something about this idea of mandatory arbitration. So Cliff Palefsky has been on the front lines of this, of this context for quite a while. And then it also appears that there's a fair amount of knowledge suppression. And Judith Resnik has done some quite exciting empirical work on knowledge suppression and arbitration, so that she will be sharing that with us. And then finally, it turns out that there is a bright spot that emerges, which is advocacy, and Chris Elliott will be returning to continue exploring the role of advocacy, both as an alternative to arbitration and as an antidote to knowledge suppression. So with that, Akhil, I will pass it over to you.
I'll dive right into it. What I want to do today is to briefly understand or talk about why we use the term matchmaking and not sharing. I'll give a very brief overview of what we do know about the matchmaking economy. I'll get into what's the main problem related to online matchmaking. I'll talk about what we do not understand from a theoretical perspective and how it links to practice. And finally, I will actually talk about how the problem can be addressed. Rather than give propositions at this stage, I think I'll just draw this out in broad strokes. So the first thing is, why the term matchmaking? I think most of us, I beg your pardon, are probably familiar with the idea of using the sharing economy. Right? So sharing is a term which we use very often. It's something which has sort of a utopian sense, and certainly most of these companies would prefer us to use that term. But as some scholars have noticed, it's not really sharing we're talking about. What we're talking about are commercial transactions, and in many cases, for example, in Airbnb, we're really talking about short-term rental activities. Now, this matters very much because from the point of view of regulation, whether you're dealing with a non-commercial transaction or you're dealing with a commercial transaction, matters, right? So typically regulators do not worry about couch surfing, which is just free, but Airbnb has attracted a lot of attention. Now, the matchmaking economy, so to speak, is expected to grow by over $300 billion. About 10 to 14% of Americans currently have engaged in some way in the sharing economy. And what these matchmakers actually do is they solve the search and calculative trust problem. Right? So from a transaction cost economics point of view, what's happening is that these transaction costs are reduced. Usually we have costs associated with search. Coase pointed this out, and this is ex ante transaction costs. And then you have the actual ex post transaction costs, which have to do with ensuring that the contract is properly executed, right? And this typically concerns the problem of opportunism. Now, this is, of course, something which is new. Earlier, we were always dependent on like personal relations and some sort of cognitive aspects of trust. So now we started doing this in a new way. And the current literature actually, not surprisingly, tends to focus on the technical aspects of trust generation, right? So how do these matchmaking firms improve the search algorithms, right? How do they match people sitting perhaps say in China and New York, right? So China and New York, how do you match those people, right? It certainly looks at data encryption, self-representation. So Alibaba, for example, allows users to talk in real time. Reputation scores are a big factor, and reputation scores allow you to judge whether your prospective exchange partner can be trusted. So it's a kind of a risk probability calculus. So it's a payoff function, right? But the problem is that while these matchmaking firms do give us reason to believe that anyone we might want to transact with might be trustworthy, it glosses over a very, very important governance problem. And that governance problem resolves around their ability to resolve disputes. Because if these firms don't resolve disputes when you have it with them, then, well, it erodes calculative trust. And I don't know, at least personally, I've dealt with Airbnb, and they're not easy to deal with if something goes wrong. So then the question is, the key question is, what about trust in the platform itself? So what happens when patrons have disputes with the platform? What are the kind of rules that are in play, right? So in some cases, these matchmaking platforms make it very clear that arbitration is mandatory. What are the efficiency implications which are associated with these sort of rules, right? We should not assume that they're necessarily efficient. And yet one of the reasons they exist is to actually improve efficiency in transactions. What happens when minorities are discriminated against, right? So research has shown that Uber drivers, if you're not white, there's a 30% higher likelihood that Uber drivers will cancel you. Airbnb suffers similar problems. Uber is actively arguing that they are not subject to the ADA, the Americans Disabilities Act of 1981. And it's worth considering whether we really want these kind of questions to be ultimately addressed by private players. So it's private governance or private ordering, as Williamson might call it. Is that the right way to go about this? Well, to think about this, we actually, the way new institutional economics talks about applies to understand economic transactions, is it understands that institutions play a very, very critical role. Now, institutions are comprised of two things. There are formal rules of the game, which would be regulations, and there's informal rules of the game, which are norms. Like, for example, in the diamond exchange market, every time you consummate a transaction, it's customary to say the word mazel. I apologize if I'm mispronouncing it, but this comes up from the Hebrew tradition. I think it's a Hebrew word, but it's used in Mumbai, in India, where there's absolutely there's no legal reason to do that. So informal rules of the game are those rules of the game which cannot be legally enforced, but are actually expected and enforced by the community. And then there's the play of the game, and that's where the action is, right? So you have the formal rules of the game which decide what kind of transactions can take place. You have the informal rules of the game which sort of provide also an equilibrium in terms of what you can expect. And there's the play of the game where the different economic agents come together and interact. And this is shaped by these institutions. And this ultimately leads to calculative trust. As I mentioned just a minute ago, that this calculative trust by necessity, as Williamson characterized it, is a risk probability calculus, right? So I can look at somebody in the past, observe their behavior, and figure out whether I should trust them or not. Now, how do we actually address this problem? What can help us, or what can patrons or players do to sort of make sure that the matchmaking economy or that matchmaking firms do not act opportunistically? Well, there's two broad mechanisms which can help. One is exit, and one is voice. So exit is the simple idea that you can exit a transaction. And of course, to exit a transaction, you should not incur a very high cost, right? And voice is the idea which directly looks at information asymmetry, right? So it's very important to have information out there so that people can actually make their own choices in an informed way. One of the ways to do this, and this speaks to policymakers, is and advocates, in fact, is to reduce entry barriers. So the reasoning is fairly straightforward. If you have low entry barriers, you have more players in the market. If you have more players in the market, it allows people to exit and choose different options, right? So this directly addresses the monopoly problem. Mandatory information sharing, right? So a lot of times the rules imposed by these companies don't allow you to share information about your disputes or other information. And by making it mandatory, you sort of allow policymakers can sort of help the market doing what it does very well, which is to generate and systemize important information. A third thing is to strengthen market selection forces. How do you do that? Well, you have new entrants, right? And also multi-homing. So this obviously works very well for patrons who don't have specific reputations on a particular platform. So think about it. If you're a superhost on Airbnb and you want to move to an Expedia platform, it's difficult because here you have established a high reputation score, which means that patrons would be more likely to trust you. But you move to a new platform, you do away with that advantage, right? And so how do you do that? Well, again, how do you lower the cost of exit? Lower asset specificity. So if you think of firms or entrepreneurs who can actually provide a more generalized score, which can be used on other platforms, you increase the ability of people to move across, to exit, right? And it's also obviously a form of voice. So combine these sort of mechanisms towards exit and voice can strengthen markets, can sort of help reduce information asymmetry, help reduce asset specificity. And I think the expected outcome of following some of these, thinking about this or following some of these ideas I would say it might increase calculative trust. It'll also help in better dispute resolution. And Adam Smith had this idea that it's really important to extend the extent of the market. The matchmaking economy at least has the promise to be more inclusive, right? So more inclusive in the sense that it can help lowering income groups, it can help vulnerable groups, and by reducing information asymmetry and making the game more fair, it can possibly meet that promise. But obviously, it requires careful consideration. That's about it for me.
Great. Thank you so much, Akhil. We have now firmly established that this is very much about trust and it's very much about voice. With that, Cliff, it's over to you. Please tell us about what do we need to know about mandatory arbitration?
Well, thank you very much. First of all, when it comes to the platform, trust may be important. I got to tell you that in the real world, when it comes to dispute resolution, I'm not sure that the companies are very concerned about trust. I think it's all about limiting liability. I hate to be cynical about it. I think that alternative dispute resolution is very important. My bias, even though I'm a trial lawyer, I don't think that's the best way to resolve most disputes, especially consumer disputes, especially small disputes. I think a good ADR program enhances justice in many respects, but it's got to be fair. Arbitration is not a justice system, for those of you who aren't familiar with it. It's a dispute resolution system, sort of like flipping a coin is and throwing darts over Rochambeau. It's important to understand that ultimate justice is not its goal. Finality and resolving a dispute quickly is the goal. And what I mean by that is originally we've got a relationship, a union or a construction project, and we're going to have to keep dealing with each other. We have a small dispute. What's the best way to resolve it? Let's find somebody that we have complete trust in, both of us, with no reason to favor either side. Let them make a decision as to what they think is fair, and right or wrong, we're done. It's over. There is no appeal. And believe it or not, the law is that an arbitrator's award has to be turned into a judgment, even if there are errors of fact or law on the face of the award that result in a substantial injustice to the parties. Think about that. Even if there is a mistake on the face of the award that's wrong, it's over. Now, that's sort of, you pay your money, you take your chances. If you know you're getting into that, if you decide you want to use that form of dispute resolution, it's absolutely fine. But as a mandatory form of dispute resolution, especially when there are legal rights involved, it obviously becomes a problem. Arbitrators are not required to know or follow the law. Okay, and in fact, in many circumstances, like in the securities industry, they're literally told you are not obligated to follow case law or statutory law. And the purpose of ADR and arbitration was to provide an alternative to courts, to stay out of courts. So the only check and balance that was ever contemplated to keep the system fair was consent, that the parties jointly agreed to go to arbitration, and they would only agree if they had the ability to choose an arbitrator they had complete confidence in, and a set of rules that they felt was balanced. And when you eliminate consent, you literally eliminate the only market force to ensure fairness. Now, that's a problem when you're talking about trust, because no system of justice can succeed without the confidence of its users. And the mere fact of imposing your system of justice on another party is inconsistent with the sense of what's required. Why are you forcing me into your system with the arbitrators you choose and the rules you choose? And that means that someone who loses will never accept the result as being valid. And even in those circumstances when you win, you wonder whether you would have won more or done better in court. From a policy matter, from an intellectual matter, you got to understand that arbitration is an adversarial system. and you can't turn an adversarial system over to one side and say, you make the rules, you choose the arbitrator, and you decide how it goes. How did we get here? Well, there's been a lot of dishonesty on many levels, starting with, unfortunately, the United States Supreme Court and corporations trying to pretend to be creating access when really their goal is to limit liability. The courts and others have said arbitration is just another forum with no impact on your substantive rights. And for those of you familiar with jurisprudence here, that's it's a modern day version of separate but equal. In fact, if any practicing lawyer said arbitration was just another forum equivalent to litigation, if you will, or public dispute resolution, it would be malpractice. I mean, absolutely per se malpractice, because it is the opposite in every single material defining respect of what we consider to be due process and justice. Free versus you got to pay to get in, public versus private. I mean, think of how we used to mock the Soviet Union for having a private civil justice system. We believe in full discovery to help enhance justice and resolve disputes. So in litigation, you've got full discovery, and arbitration is very, very limited. The arbitrator is not required to follow the law as opposed to a court. There's no appeal of an incorrect decision, which is essential to due process. And most of all, the decision maker is not paid based on the satisfaction of the repeat player. Judith is going to talk about that. But just think about a system of justice where the arbitrator's compensation and livelihood is dependent on the repeat user being satisfied and choosing them again. One of the leading voices in the arbitration world who cares desperately about the process has said that any arbitrator who tells you they're not concerned about the impact of a large award on their being selected again is simply lying. It is an economic reality, and it's built into the system. And really, there are very few remedies for it. The closest we can come is voluntariness, consent, where the arbitrator or the providers need the consent of both parties to be selected again. It's why you can't turn this over to one side. Now, ADR arbitration is not mediation, by the way, is a great process. It's a voluntary process. It is a facilitated negotiation. It is less expensive and probably more efficient. And by definition, it results in, if there is a resolution, in an acceptable result. In arbitration, you completely lose control over the outcome. Now, what's happened is the concept of arbitration, which is a good concept, and I actually like arbitration. I think voluntary arbitration can be very useful, but voluntary arbitration and mandatory arbitration are entirely different concepts for these reasons. So what's happened is companies have abused the process, and they've abused it simply because they want to gain an advantage for themselves. The best example is you can say in 2 sentences, we're going to arbitrate under a set of rules. Most arbitration agreements go on for 2 pages, with every paragraph some perceived advantage. And as it has developed, it basically operates as a way to opt out of regulation, out of public justice. And it's not surprising that companies would like to never stand before a public courtroom, never have a reporter sit down on a trial, keep knowledge of other disputes from others. That's their nature. They would tell you they're supposed to try to gain an advantage. The real scandal that's happening in this country anyway is in the courts, who have allowed this to happen, who have pretended that it is an equal form of justice. And what's happened now is that in 2011, the United States Supreme Court, which hated the notion of class actions, and keep in mind, if you're talking about consumers and consumer protection. A class action, despite its abuses in certain contexts, is the most efficient form of remedying abuses in small manners. It produces the most protection for consumers. The U.S. Supreme Court has said that if you have an arbitration agreement, it's got to be bilateral, one-on-one. So basically, an arbitration clause now means that you are prohibited from bringing a class action. And that, in truth, is what is motivating the push across the universe of compelling arbitration. It's not because they want to create an easier way for people to sue or an easier way for people to get justice. It is because to limit their liability and prohibit class actions and representative actions that deal with policy or systemic problems. And a good way to illustrate what's going on in the real world is in the old days, you used to hear the phrase tort reform. It was a big, courts are out of control, judges are out of control, we need to limit damages. Tort reform, trial lawyers were the evildoers in the world. You don't hear that phrase anymore in America because the courts have basically allowed corporations to engage in what is essentially do-it-yourself tort reform. They are literally able to write their own policies. And many years ago, I was asked to be on a AAA panel to help design some fair rules that we weren't allowed to talk about voluntariness. And I saw some of their marketing materials. And the marketing materials literally said, there's been a prohibition of new statutes, age discrimination, disability discrimination, allow for jury trials and allow for damages. You don't really need to be in front of a jury. You can design your own system. It can be private. You can limit discovery. You can limit this. And they literally get up and management lawyers get up and say, you win more often, you pay less when you lose, and arbitrators don't issue large rewards. And everything that they just said is true. It's simply the truth. And they feel as though it's almost malpractice not to take advantage of that opportunity to opt out. And that's a justice system. There is no justice or trust at its heart. Now, aside from it not being justice, mandatory arbitration, as opposed to, I've had meetings with the heads of the American Arbitration Association and JAMS and said, why don't you create a menu of ADR options, mediation, conciliation, voluntary arbitration, and help people choose the right process for their case? But that's not what they want to do. They don't want to market their fairness to both sides. They've decided that it's easier to make a deal with a corporation and have the corporation use its leverage to basically impose their system on millions of people at a time. So whether it be Airbnb or PayPal, either JAMS or the American Arbitration Association needs to just get written into their contract. And now they have a captive caseload of thousands of cases. And it's lucrative for them. They have one large customer. They have account managers whose job is to keep the customer happy. There's been examples of them putting panels. Here's our panel for this kind of dispute resolution. What do you think? They actually market themselves to the companies by showing them the panels. They literally craft the rules to make it acceptable. Before the Supreme Court outlawed class actions or made arbitration a way to avoid class actions, there was an organization called the National Arbitration Forum that literally marketed themselves as the way to prohibit class actions. And as I'll give you a good example of what's happening now. In an effort to avoid class actions, companies said, let's have individual arbitrations, and we pay for the arbitrations. And they knew that most individuals would not bring an arbitration for $50 or $200. And they used it as a way, as Judith will describe, of suppressing claims. So what happened was the plaintiffs bar said, okay, you want arbitrations. Now we have social media. In the old days, without a class action, you'd never know how to reach your thousands of consumers or victims. Now you do. So people started bringing hundreds separate arbitrations, and the arbitration fees became millions of dollars. And all of a sudden, the companies are going, hey, we don't want to arbitrate. This is unfair. And the courts have no sympathy for them because obviously it's their own system. So what's happening now is the providers are giving them a life raft. They're changing their rules and how they're charging because they don't really care. They just want the flow of business to keep going. So it has corrupted the arbitration process. It has corrupted, money has corrupted the providers because they are a for-profit business, and for-profit justice is obviously an oxymoron. And it has also corrupted the courts in this country. And let me explain why. In the old days, judges would want to sit on the criminal bench and lock people up and throw away the key. But that doesn't set you up to go into this very lucrative post-judicial employment of ADR. So now they're literally fighting on the bench to sit in civil courts where they see the big corporate lawyers and in family court where they do the family law. And we've had judges, testify and say, you don't want to be an out-of-town lawyer coming into federal court because judges are now hiring consultants to teach them how to make themselves more attractive to these ADR firms. The judges are tired of making $150 grand a year when their friends are making $1 million a year as a private judge. So they've created a very lucrative supplemental retirement system. And as a result, docket clearing, judges just not thinking these consumer disputes or employment disputes are worth their time, are looking at arbitration as a way to simply clear their dockets. And they've come up with what I call simply a phony public policy of docket clearing, as though public policy favors arbitration when it can't, because in the United States, we have the First Amendment, which is the right of petition. We have the Fifth Amendment, right of due process, to have the right to have the law enforced correctly. And we actually have a constitutional right to trial by jury in a civil case. So when the courts themselves are engaged in this misrepresentation of the law, there's something really wrong in the House of Justice. I mean, think about it. We've got judges here who are appointed for life, who would simply used to be appointed and you stay and you go senior and that was your life. And now sitting judges, including state Supreme Court judges, are being recruited off the bench. While they're sitting, they're being recruited like free agents to go work in the private arbitration world. And it is not surprising then that you keep reading decisions that say public policy favors arbitration, written by the same judges who basically say judges are not supposed to make public policy. So just one or two other things. In order to address the high cost of arbitration, and in my world, in an employment case, it could be $100,000 because the arbitrators are charging about 10 grand a day per arbitrator. The American Arbitration Association charges a filing fee based on the amount of the claim. You can have, there's claims where you got to pay $16,000 just to file the case before you even start dealing with an arbitrator. So the courts realize that, wait a second, intellectually, how do we get around that? And on some cases, they think the employer should pay. So the employer says, okay, we will be responsible for paying the cost of the arbitration. Sounds interesting, except traditionally, historically, and legally, people were always supposed to split the cost to make sure that no one side was the client and that there was no bias. But what's happening now is companies start off paying, and if they don't like some of the rulings, if they think they're about to lose, after a year of arbitration, they stop paying. And instead of finishing the case, these purveyors of justice say, no money, no decision. And we're seeing cases working their way through the system, and then the company simply stops paying. So we have in the process undermined what could be a very, very valuable process. We've undermined the courts, and unfortunately, trust no longer the goal in dispute resolution when it should be. So there is a scandal in the House of Justice. I've been doing this now 33 years, fighting and standing on the mountaintops. And there seems to be some recognition of its injustice in Congress here, but not enough will to really make a big difference. So it's really dependent on academics like yourselves and people who may have some influence in the corporate world to impose some real sense of fairness and justice, but it's not there now. Thank you.
Thank you very much, Cliff, for that. Quite inspiring, bringing us up to speed on this world. And Judith, would you please terrify us with what you have to add to what Cliff said?
Hi, so I'm going to try to share screen and show you a few things. There'll be overlaps and additions. Okay, so I want to start by, this is a 1726 frontispiece from a famous book that was compilation of various treaties, most Europe and non-Europe. And you see this kind of idealized picture, gender white dominated, of men shaking hands with the virtues at their heralding their delight and the vices slayed below, in this idea of a concept of peace. And the relevance of it to today's world is that it became the template for the Permanent Court of Arbitration at The Hague. This is the pre-2007 version, and you've got the Eye of God, but when you move to the post-2007 version, you don't have the Eye of God. But what you're seeing here, and there's obviously potentially colonialism and lots of other things to worry about in this imagery with the Peace Palace and the back at The Hague, but you're seeing a concept of a form of agreement and consent. Now, actually, in the English US tradition, at least in the US side, courts were, before the 20th century, hostile to arbitration because you were intruding on their turf and did not enforce agreements to arbitrate. And in 1925, with the American Bar Association and the nascent American Arbitration Association at the helm and the New York City Bar, the US Congress passed what's called the Federal Arbitration Act in 1925 that said, hey, courts, and one version of interpreting it is, hey, federal courts, and it might not even apply in state courts, but at least in federal courts, this agreement to arbitrate is enforceable as compared to ripping it off. So in returning to Cliff's idea of two people coming together to agree, and then one bails, then the idea is actually it's enforceable. Now, the second paragraph I've stuck on the screen is it actually, per Cliff's expertise, doesn't apply to interstate commerce workers. And the important part for anybody inside US constitutional law in 1925 is those are the only workers Congress could regulate. So a reasonable reading of the statute is that it applied to consensual agreements that did not affect workers whatsoever in any way, shape, or form. One version is, as I mentioned, it applied only to federal courts. It has been interpreted to apply to state courts as well. So this is 1925. And for more than 50 years, it was interpreted as not applying to workers. But if we move forward to the 1950s, it's also understood as to be concerned about egalitarian bargaining. So this is a case that the US Supreme Court decides that says, no, you can't, commercial stockbroker cannot enforce this against a purchaser, or you're accused of churning, a customer basically, because while it's a form contract, it's a form agreement, and you drafted it. So we've got a process problem. That's the first paragraph. There's a problem that it was drafted. We don't want to disadvantage you. The second is, hey, arbitration. It's basically lawless. It doesn't have to, per Cliff's discussion, could have a record or reasons or appealability or burdens or all those things. And we're the federal courts, and we're in a regulatory mode. And these are the securities regulations, by the way. And we just had a big depression, and that's where they came from. So this is not enforceable because we've got a problem in terms of the lawlessness of arbitration, which is flexible and the like. Now, the quick forward is that not only does it become enforceable, as I'm about to show you, but we shouldn't conceive of courts as themselves thinking of themselves as regulatory, because it's not only in arbitration, but other areas where the US federal court system has said, we're just a dispute resolution mechanism too. So the shift in arbitration being revalorized and courts being reconceived is another piece of this. But if we get, so 1985 marks the first time that a court in a more complicated case says, yes, we'll enforce this mandate, even though we don't think it was necessarily a bargain, as long as we're sure, and now it looks like there's some oversight about the quality of arbitration. Here is a document that comes from a case called EOC versus Baker, and it's Waffle House. You can't read it very well, but that's actually part of the point, because there's no point in reading any of these things because they're mandates and you can't negotiate them. But I want you to actually see what it is that a worker, a guy named Eric Baker, who had epilepsy, as it turned out, signed at Waffle House, which says it's America's place to work and America's place to eat. And it's this scribbled thing, and you see this tiny print, and I've blown a little bit of it up. So one big paragraph says basically, don't eat the waffles. And it's in bigger size, and it makes sense it's in bigger size because the guy's more likely to eat the waffles than to go try to sue. So it says, don't eat the waffles, and we can penalize you, and we can cost you money, and you have to take a polygraph. And then the next part says, if and when there's a dispute, you're going to be under the commercial rules, you're going to go to the American Arbitration Association, and we're going to split the cost of the whole thing. And so Eric Baker is unable to work because he has epilepsy. He seeks protection with the Equal Opportunities Commission, Equal Employment Opportunities Commission, as a disabled worker. The company says, not only can Eric Baker not bring this lawsuit, but the EOC, Equal Employment Opportunities Commission, cannot either. And the US Supreme Court says, actually, there's no, if you go back one page, EOC doesn't sign here. EOC is not precluded here, although it assumes that Baker is precluded in this. And by the way, he's precluded at a different Waffle House than the one he had signed up for. This piece of paper comes from actually a piece of paper I received, which in decades ago said to me when I had my phone that I basically agree that I will be in mandated arbitration and precluded from doing anything collectively. Now, I actually called up the company and said, whoa, and they said, you're welcome to stop using our services. And so it is, there was a wonderful law professor at Yale called named Art Leff, and he said, if it's neither negotiated or negotiable, it's not a contract, it's a thing. And so it's a thing. You may want to regulate it or not, but to call it a contract is actually category error as an analytic matter because it's not a contract. So what we know about this thing is that when California courts, where Cliff sits, saw such of these things, which is trying to keep consumers from clustering in order to, and mandating the waiver of collective action, the doctrine, which calls it an unconscionable contract, says we're not going to enforce it. And there's both there was a California statute as well as a California case law on this. And then you get to the US Supreme Court in a case decided by Justice Scalia, written by Justice Scalia in 2011, which involves AT&T. And Justice Scalia takes that antique 1925 statute in a world that didn't have class actions of the kind we think of today at all, and says, it's in that you California cannot do anything as a barrier. So federal law preempts state law because Congress, not we the courts, Congress wants to be sure that everybody can arbitrate as much as they want. So this actually, in the opening, there was this idea about private ordering. I want to underscore that all of this is an artifact of law. And I mean, there is private ordering. You and I agree to something and we never go near a court. But once you're in a regime where you're trying to enforce it against somebody who's balking, then you're actually looking at a world of of law. So the justifications for this, the idea of this is, and you already heard from Cliff, that it's consent that is a source of legitimacy. And the other justification is it's more consumer friendly, it's more useful, it's more efficacious, it's cheaper, it's better than courts. So if we start here, this is a grab from the web in 2019, and it just said we can do anything you want. So again, there's no consent. If I get a bundle when I get my phone, I don't consent to anything because I'm told that they can change the terms and conditions in any way, shape, or form. So then the question, so if one is, it can't be really validated because there's no real robust consent that's operating here in many arenas, not all, but in many, then the next question is, well, maybe it really is better, cheaper, easier. We heard the pro alternative dispute resolution mode. So how could we know about that? Thank you, California, probably thank you, Cliff, directly, who's very involved in all this legislation. There's data basing required on what California actually capaciously defines as consumer arbitration. And it says you've got, and the reason that Suzanne could go to the AAA website is because this statute, it started existing in 2003 and has been amped up since then. And it requires data basing of the non-consumer party, the nature of the dispute, every quarterly, and I should actually say it's put up every quarterly, and it's actually they take down the last quarters on their 5-year spread. Me and some students harvest the data, and there's a database at Yale that anybody can go to look beyond it, so you can get more of this than is otherwise available on the AA web. And if any of you, with all the talents you have, want to do this, we'd be thrilled at its use. So you get the name, the nature of the dispute, the prevailing party, whether there's a lawyer, the type, the amount, the duration, to some extent, the name of the arbitrator, some demographic data about them. And here's what, and I really mean the word we, because it's talented students who have this skill set. I obviously was honing in on AT&T because AT&T is the name of the case that the Supreme Court licensed the preclusion of collective action in, which wasn't at all obvious in terms of statutory interpretation. And basically, if you go to the bottom side on consumer filed between 2009 and 2019, as far as we can tell, 90 new filings. If this is in that time period, AT&T had between 80 and 140 million customers, according to its web. If this is the best thing since sliced bread, one is we'd all be volunteering. It doesn't need to be a mandate. And two, on top of being volunteers, a lot of us would use it. And there is Zippo evidence. Why? I've actually read those. First of all, figuring out what rules to use is hard. I teach procedure. Those rules look well written compared to some of these rules. So it's hard to figure out. Second, of course, we heard there's a filing fee. Third, these are often small value. So in the whole arena of activity, there is a poignantly small number of filings, as in basically no one uses this. And the company, which says it loves it to death, doesn't use it at all against us either. And the mutuality of a requirement is partially required under some state interpretations. So if we go then to just try to, these talented students tried to find out, yes, there are a few awards, and notice the numbers don't jive because I was looking first at filings and now I'm looking, and they pend and then they stagnate and maybe they die or maybe they move out. So there's a different number of terminations in the same time period as there are filings, but you're looking at relatively small dollars in all of this. And I'm also been told by, you can call the company and maybe get some of those resolutions as well. So another part is, one piece is, as an individual matter, collectivity is the sine qua non, because people have neither resources, energy, capacity, knowledge, utility. So if you can't go as a group, you hardly go at all. And so you lump it, is the terminology and the sociology of dispute resolution. So then you get to the next. I was asked to write a paper for a symposium, and this came on my desk. So now we're at American Express, and I'm supposed to read it and keep it in a safe place. So I've given it to you on this PowerPoint. And again, it says that the arbitration is single, cannot be joined, consolidated, unless we, you and I, meaning American Amex and me, agree it's only a specific case, it's never enforceable. And the one that I've blown up is we are agreeing that it's confidential and we can't disclose the content. Now, as Cliff will tell you as an employment lawyer, there may be instances when some of his clients want confidentiality for a variety of ways. as a consumer of American Express or AT&T, it's hard to in low-level consumers, it's pretty hard to figure out why I want confidentiality, but of course I could ask for it or just not tell anybody. This is a mandated NDA silencing non-disclosure agreement. Now we're back at law. So one answer is, hey, you can't do this. What are we doing here in this? And that very clause was held in 2003 in a decision by the Court of Appeals on the Ninth Circuit, which is all the whole federal West Coast side, that this is the provision, this is basically the same. And the court said, nope, it's a gag order. And you've got a repeat player advantage, and it's totally unfair. And AT&T knows everything about the case outcomes, and the individual knows nothing, nor is supposed to share, can't use it. We live in the United States, in a vibrant federal system. That court doesn't bind other courts in other parts of the United States. So goes the AT&T and brings the same clause in the southern part of the United States before another circuit called the Fifth Circuit. Singular becomes, is bought by AT&T, and in other iterations, basically same clause. And here you have a federal court saying, well, yeah, it favors the provider a bit, but it's not that offensive, and confidentiality is really good for arbitration. And of course, you really can't get precedent, so it's okay. So there is litigation around that in various parts of the country. I want to be sure to bring to the fore that I live in a system in which state courts play a vital role, and there are some state courts that say, looking at the same clause, sorry, not enforceable. So here's a little snippet from the state of Washington that doesn't say as a matter of constitutional law you can't, but invokes the constitutional open courts notion to basically say it's an unconscionable interpretation. It's unconscionable and it's not enforceable as a matter of state contract law infused with a concern about public policy that comes from the constitutional provision. So the next is that in the world of Me Too and employment lawyering like Cliff's, we get to some state regulation. So there are some state statutes that render unenforceable non-disclosure involving sexual harassment and sometimes discrimination claims. And I've given you both Washington and New Jersey. At the last count I did, there were more than 13 states that had these provisions of making the non-disclosure unenforceable in a subset of arenas. And just a month plus ago, the US Congress did likewise in sexual assault cases that also make unenforceable the making the arbitration obligation unenforceable and making the non-disclosure unenforceable as well. And so it's a subset, which is just a reminder that this is not comprehensive. Now, I've dashed to Europe very briefly and actually gone back in time. And I did this, there's more European regulation. This is not the most recent, but this is all law, and there's another way you can approach it. So regulation of alternative dispute resolution, which is often increasingly online dispute resolution, as in ODR, can occur. And so you can have one form of regulation that says database all your provisions and information sharing, information obligations, and the like. And then you can also have it be that you can only go if you're a volunteer. And then another critical facet is that it could be required but not preclusive. So the key, which goes back to Cliff's underscoring of finality, in the US context is once I'm there, I'm one and done. Whereas in some systems, yes, you may use it. Yes, I may tell you you have to use it unless you are don't have a computer capacity. But if you use it, it doesn't push you out of court with the backdrop here of Article 47 of the Charter on access to courts. So it's not replacing, displacing, depriving, or the like. Now, the laws move forward in this, but also, as some of you may know, the law on collective redress in Europe is also moving to enable more. So I just want to wrap up before we have, and I know others are going to speak and we have time to talk, by flagging that the ideology of this open courts, this, I'm giving you pieces of state constitutions, Connecticut and Alabama from 1818 and 1819, was all courts shall be open to every person. But before anyone gets gleeful, please understand that every person in 1818 and 1819 was not all those people who are sitting here on the screen, as in women and anyone of color in Connecticut or Alabama, did not have all remedies in due course of law. And the ideology, of course, also had judges that were independent and in the federal system and in some states protected in a way that Cliff has noted as not. And this last picture, which is there's a great photographer named William Cliff. This is a photograph taken, there's Seagram's Corporation had a project of taking photographs of courthouses in the 70s. And so you see in the center, the old St. Louis courthouse. And the St. Louis courthouse is famous in the United States in St. Louis, Missouri, because it's where the case called Dred Scott, in which the US Supreme Court nauseatingly said that people who were freed slaves or blacks were not actually people and had no juridical capacity at all and could not bring lawsuits. And after the Civil War and after the 14th Amendment, in another case called Minor versus Happerstat, the US Supreme Court again nauseatingly said, yes, you're a woman, Virginia Minor, but that doesn't mean you can vote. That's up to Missouri and you can't vote. So this image is important, first of all, because there's no romance of courts. Law is not fair and just unless the political and social movements make it fair and just. So it's not law per law, but the quality and content of law as a non-discriminatory predicate. And that's a post-World War II 20th century phenomenon that we're watching being whittled away in a variety of ways. And of course, the war in Ukraine being jaw-drop horrific. So this is to remind you that courts are important. They are regulated. They have the public aspects let us contest Drew Scott and Minor v. Happerstat, but no, like starry-eyed, it's court, therefore it's okay. The second piece is that you're seeing the international style building was in a great big insurance company at one point in Missouri. And the reflected building that sandwiches was at one point the headquarters of the American Arbitration Association in that part of town. And the old St. Louis courthouse is actually now a museum. It's not a functioning courthouse. So what we may be looking at in this trajectory is those monumental amazing instantiations of a set of aspirations for a thing called public courts with fancy-dancy buildings or more modest buildings are incredibly vulnerable institutions. The ideological predicates that got formed that made them inclusive in the 20th century are completely under siege. And this one piece of it, called private ordering, is infused with public energy to deregulate and disaggregate what many people tried to build to be identity of democracies in eras past.
Thank you so much, Judith. That was quite brilliant, and you have really brought to life for us the nature of the siege that we're under. And come on, OM community, we need to step up to the plate. So to interject so we've been hearing some pretty concerning stuff, and I find that the work that Chris Elliott has been doing brings a lot of hope. So Chris, the floor is yours.
My name is Christopher Elliott, and I'm sure Suzanne introduced me before. Unfortunately, I wasn't there for that. I am the founder of a small nonprofit 501c3 called Elliott Advocacy. Our mission is to help consumers when they have any kind of a small consumer problem. We're here to help empower consumers to solve their problems and to help those who can't. And we do it through a couple of different ways. One of them is through direct consumer advocacy. So I have a team of volunteers that I work with, and we get emails and from people who have disputes, and we review them and we will mediate them ourselves. We also do it through journalism. I'm a published writer and an author, and I also write several syndicated weekly columns that are distributed fairly widely. We also maintain the largest database of executive contact information. So if you have ever been in a situation where you've said, I need to speak with a supervisor, and the person on the other end of the phone says there is no supervisor you can speak to, well, what we've done is go out and research the names, numbers, email addresses of the corporate executives who are in charge of customer service. And we have found a lot of really great information out there. Sometimes we've even published the home addresses and home phone numbers. Inadvertently, we took those down after a while. We also train and equip other advocates as part of our mission. This is a relatively new part of what we're doing, but we're looking forward to actually certifying consumer advocates at some point in the very near future. So we've developed a training course. We're going to unleash a lot of other consumer advocates out into the world and hopefully show them some of the knowledge that we've gained over the last 20, 30 years of doing this. So I wanted to talk a little bit about first how I came to do this and how the nonprofit came to exist. Back in the mid-90s, when I was a cub reporter for a travel magazine, I noticed that a lot of people were contacting me and saying, look, I've got a problem with an airline or a hotel. And back then we didn't have an Airbnb, but we had a lot of hotels and I need help. And so back then the internet was such a new thing. And I decided just as an experiment to mediate these cases and to publish the cases online. And that really took off. And after a while, King Features Syndicate asked me to write a syndicated column, and we developed the website and got a real following. So now at this point, I have probably 30 to 40 active volunteers who work with me doing research, editing, writing, and of course, advocacy as well. So a little bit about how we collect our cases. When someone emails me and says, I got a problem, Chris, don't know what to do, the first thing that I do is I send them to our website. We have a form on the site at elliott.org/help, and we collect all the data that we need to get to make an assessment to see, does this guy have a good case or not? When we get all that information, we will actually get in touch with the consumer and say, usually we'll say, hey, we need a little bit more information from you. And specifically, could you send us the paper trail, which is the correspondence between you and the company? And if there is no paper trail, we say, please get a paper trail. Because what we want to do is give the company an opportunity to respond to the consumer and to resolve the problem. Usually, though, it's gotten way beyond that. We deal with a lot of intractable cases. And so what we'll do is our volunteers will have a look at what the case is, and they'll look at all the specifics, and then we'll say, all right, this is something we can either mediate or not mediate. So direct mediation for us means that we take all of the correspondence, we provide a short assessment, and we'll say, well, we think that maybe the company may have overlooked this, and then we will send it to our contact. We have contacts at these companies, and we'll ask them to take a second look at it. Now, the advantage for us is that we do journalism as well. So there's an implied threat that if you don't help us, we'll probably write a story about this and it'll get published in the Chicago Tribune or the Washington Post. However, our approach is that we do not ever threaten anything. We want it to be collaborative. There are a lot of options that consumers have. We're happy that they've chosen us to mediate their case, but we also want to be as fair as possible. So we never say, hey, if you don't do this, we're going to, you'll find yourself on the front page of the Wall Street Journal or something like that. Never anything like that. It's always very collaborative. And indeed, sometimes we'll find that the company will send us back their file on this case, and it will actually exonerate the company. And someone may have overlooked a fact when they contacted us, and we'll say, look, we really can't help you. You forgot to read the terms and conditions, or this was a non-refundable flight, or you're past the warranty date, something like that. In which case, really, there's nothing that we can do. But when the company has really screwed up, we want to be there for them. I wanted to quickly talk about two cases. One, which I just published on the site, involves a woman named Claudia Lockwood. Claudia had rented a car from Avis, and she dropped it off at Hartford Airport. When she dropped the car off, it was after hours, and she asked the company where she should leave it, and they told her. She dropped it, left the key there, and then flew to Berlin. So she was out of the country. Then Avis decided to charge her $4,228 a month later. And it turns out that Avis did not accept her return vehicle and couldn't find the car. When we contacted Avis about her case, it didn't really take the case very seriously. It said, look, we're going to settle this. We'll give her $600 back, but we're going to charge her the rest. So our team had a little bit of a discussion. We ended up having a look at, we did some sleuthing. We had a look at the specifics, and we looked at the satellite image of the parking lot where Claudia dropped off her car. We realized that that parking lot was so small, it was inconceivable that Avis could have lost a car on that parking lot. One other interesting fact was that in her rental agreement, Avis had said that it didn't allow after-hours returns. So they were already violating one of their rules. So we said, look, we contacted Avis and we said, guys, first of all, you don't allow returns after hours. And second of all, did you really lose a car on a lot of this size? You have to look at the lot. It's, maybe 30 or 40 parking spaces. So at that point, Avis decided that it was going to refund the $4,228. We get cases like this all the time. Now, I wanted to mention another case. This is probably Suzanne's story to tell because we worked on this together. I'll let her do that. But we get a lot of cold cases that are a year, 2 years old. This particular one was involving a refund case. It was a request for a refund, and it had gone to arbitration, and then it had gotten dismissed. So the company would not arbitrate it. It had gone on for 2 years. Suzanne and I had talked about this case for, it seems like at least a year. I ended up contacting the company, and within about, I want to say 48 hours, it was resolved. So that's the kind of thing that we do. Very briefly, the benefits of one-on-one advocacy. We believe that the personal touch is highly effective. So when you have an advocate who is known and trusted, and you have two parties, that they can come to an agreement. It isn't always going to be the agreement that the company wants or that the individual wants, but we usually will have a successful resolution of some kind. And then there's trust too. And I know Suzanne has talked about this a lot, but just the trust of having someone who's, who maybe it's not their first rodeo, they've advocated thousands of cases, like a member of my team or me, and people will trust us to say things to them that they will not trust a company to say. For example, you don't have a case. A lot of times the consumers who contact us will not read the fine print on their agreement. They don't follow the terms. They're asking for an exception to the rule. And we have to say, look, guys, we've done this before. You don't have a case and we're really sorry. Better luck next time. And they will trust you. Whereas if a company sends a form letter that's generated by an AI, not so much. What we have found at Elliott Advocacy is that our system can be very effective when other more traditional methods have failed. Things like trying to appeal this to an executive at a company, and when you've used the executive contacts on our site, even when you've tried to do a credit card dispute under the Fair Credit Billing Act. And usually a dispute is considered the nuclear option for a dispute. And so we've actually managed to get a refund or an apology or some form of compensation when the dispute also fails. So there is that trust factor, and that's something that that's our currency, and that's what allows us to advocate successfully when all of other methods have failed. I want to also talk a little bit about arbitration. We do recognize that it's part of the resolution ecosystem. We don't necessarily recommend arbitration for the reasons that we've already heard with previous speakers say. What we do recommend is that you go through the process, you go through the appeals process. In other words, you start at the front door with a written request for compensation. Then you take if that doesn't work, you go to one of the executives, and then maybe you contact a consumer advocate, or you go to small claims court, or you do an appeal, or you file a credit card dispute under the Fair Credit Billing Act. And arbitration for us is somewhere down the line, might not even exist as an option for most customers, because as previous speakers have said, it is something you pay for. You know, when you're shelling out $200 and your dispute is worth less than that, it kind of negates the whole thing. I do think, though, that if there were an easier to use, less expensive, and more consumer-friendly arbitration method, I think more consumers would use it, and it's something that we would definitely recommend. Thanks.
Right, thank you so much. What I love about Chris's work is that having just been profoundly discouraged by 100 years of history, or even a bit more, of what is happening in dispute resolution, if we take seriously what Akhil said and what Chris said, then we start with trust, and then we connect humans to humans, and we might be able to get disputes resolved. And our challenge is, can we use operations tools like systems thinking to figure out how to infiltrate arbitration so that it would meet these ideals, recognizing Judith's siege and Cliff's 33 years of fighting pretty hard. We have a little bit of time left. I would like to ask the question, if we were to set as our objective to focus on trust, producing trust, noticing that a lot of the companies that we're talking about in this context exist to create trust, and if we combine that with Chris showing us that we can connect humans to humans. And by the way, that day when, Chris had said, that case that, gave you a peek into the American Arbitration Association, that's a pretty straightforward case. I think I'd be able to handle that. I'm like, it was 2 years ago. And then finally, we decided to set it up as a natural experiment, and it made a powerful impact on me. When Chris came back 48 hours later, and he's like, oh yeah, the company apologizes, and they've sent the claimant their money back. I'm like, let me make you a donation. You guys, you restore my hope in in humans connecting to humans. So that was pretty great. So I would love to have us as a field do this. So
let me just interject for a second in terms of, one is that I'm trying to remember the name of the European or UK. There's a group that does a bundling. If I can't get my airline ticket back under European regulations, I have EU rights to refunds. And there's a group that is a web-based, take a quarter of the refund and help me process the claims. So, but that's to say there is a regulatory, it is one-on-one intersecting with social, political, legal structures that are obliging in Europe, some forms. If you try to go to Akhil's, that there's a reputation trust idea, and Chris says, I'm not putting it on the front page of the Wall Street Journal, we may have privatizing. The reason that you get a non-disclosure clause is to not let other people know of this. You're obviously web-based so that people know there's a route. But then the question is, and one of the reasons to suppress information, even when there's pathetically little claiming, is to prevent the Cliffs of the world to be bundling claims. So they're filing individual arbitrations, and 1,000 of them. And that, of course, has become a new aggregation in arbitration by single file filing, is the sort of next wave of the interaction. So in terms of the sort of building trust, it has to be in a system in which people who aren't insiders have access to knowing, but it also requires something beyond mutual, yes, I'll do it for you, which is to say, I should do it for you. And the should has to come from some regime that takes seriously, takes seriously what it is that interactions are supposed to produce. And law has been one repository of it. It's not it intersects with, it's certainly not the only voice. So I wanted to sort of even ask Chris and Cliff and Akhil how the model that you, Suzanne, and Chris are suggesting can become, what's the scale and scope? Because if it's not scale and it's not public and it's not somehow a set of default obligations, it is idiosyncratic one-on-one, but it isn't transformative.
But I got to tell you, I love what Chris does. He's effective in part because of his journalistic background. Companies are afraid of the public disclosure of these disputes, whether it be through a newspaper article or social media right now. And that's what helps make it very effective. I don't actually bring class actions. I'm not a big fan of doing them myself. I think that on policy issues that affect a lot of people, it is effective. For individual disputes, one-on-one, I don't know what would matter other than a commitment by the company to this trust. And I think that there's trust in the use of the platform, like in who do you share your house with. But I just don't see many companies trying to involve trust or that kind of justice in one-on-one dispute resolution. I just think it's a matter of limiting liability and exposure. And I think as a culture, we need to get back to a more trust-based relationship, even in the commercial setting.
So if I can just jump in on that, I think the word trust is often misused, at least in business relationships. That's the idea that Oliver Williamson tried to actually elucidate on in quite detail. And so he actually said, let's not use the word trust, it's too colloquial. In the business setting, what we're looking at is literally looking at is what's my payoff, what's my risk, let's do a calculation, does it make sense to engage in this transaction? So when I use the word calculative trust, I'm literally talking about only that, right? Going back to Judith's point, I fully agree. I mean, if you recall the slide I'd shown, it talked about the informal rules of the game, the formal rules of the game, and that affects the play of the game, right? And so in Europe, what's happening with airline refunds is basically the formal rules of the game, the regulations are set up in a manner which allows the play of the game to occur in a manner where you can get refunds, right? With advocacy, of course, I see it's a valuable tool, but it's also really important to have an expectation. So this economist term, the idea of an expectation equilibrium, which is when I get into a transaction, I should be able to figure out how this is going to play out, right? And advocacy is extremely important in bringing to light information, which goes back to Judith's point that we really have to have this information out there. But as a reliable tool to constantly ensure that en masse people are not being cheated, well, I'm not sure that can work. It's not scalable, right? So we're really looking at we're looking at a limitation of scale for individual transactions. And the question is, what rules of the game, formal and informal, can we design that can make the play of the game occur in a manner where these firms cannot act opportunistically? And that's really, I think that's the tough question. I wouldn't trust these firms. I have no reason to believe that in a business transaction they will act in any way in which they care about my interests. They're interested more often than not in maximizing their value, and as am I as a consumer most of the time, right? So the question is what, and these firms are great at making sure that if I interact with somebody, that other person doesn't take advantage of me. But the key question still remains, why? What warrants calculative trust in these firms? And that has to come, at least as I understand it, has to come from the rules of the game as well, which would then be regulations, which can be mandatory information sharing, which again, by being suppressed is quite problematic. The American Express slide that Judith showed was actually pretty shocking to me. I use Amex. I'm like, whoa, I didn't know that. I never looked at it. I don't bother to read this stuff. But yes, it's crafted to favor these companies. But then well, the level above that slide, by the way, which I didn't mention, about the informal and formal rules of the game, especially those here who understand the law know this way better than I do. As I understand, and please correct me if I'm wrong, the law is a reflection of the values that a society holds ultimately, right? So, and that takes a long time to change. And I have and that's just way beyond anything I understand.
I wanted to mention just for your information, the law that, the regulation actually that Judith was referring to is EC 261. It's a European consumer protection regulation for airline passengers and train passengers. There's one for train passengers as well. The company that you mentioned, there's actually several of them, and
Yeah.
they're highly automated. You don't really get a personal touch, unfortunately. You just fill out a form, and they do take, I think it's a quarter of whatever you're getting. But if something goes wrong, or if the refund isn't coming on time, they'll give them a little push. Our solution is, and it's not really a solution, it's more of a stopgap, is to train more people to be effective advocates for themselves. So we want to give away all of our secrets for how to advocate for yourself. Tell them where all the skeletons are, give them the information that they need on regulations and law, and then cut them loose and let them be their own advocates. Until we fix this problem, I think that this is the next best solution.
So in the nomenclature of courts now, there are people called navigators, and navigators are people like you trying to help people in exactly the very clear way you just explained it. There also was the idea that what you were doing is something called practicing law, which is to say that when lawyers function well, they're functioning to figure out how to fix problems, and by knowing who to call, and sometimes by calling with the authority of being a person named lawyer, you are able to get attention that is not there. Now, you also have to pay attention that sometimes calling yourself a lawyer screws somebody, and that you have to think through how to be effective. But the front end of 100 civil cases filed in the federal system, one will start a trial, if that, but of 1,000 disputes, fewer than 10 in a court system when we didn't have arbitration, we're going to get filed because much of the work is figuring it out without going to court singularly or as an aggregate. The issue becomes, what happens if you're blocked? How do you generate information? And what's the regulatory apparatus? And Europe is still, we'll see how Europe fares, much healthier as a regulatory environment. The US Chamber of Commerce is super active in Europe. It's called the international whatever, in trying to limit regulation and limit collective redress. And the people thinking collective redress has a contribution, while they're also trying to regulate lawyers energetically in the process so as to not have too much rent seeking, is peace is a part of this. And so to me, the question in your model, which is a great contribution, would be, how do you generate political normative commitments to the forms of social justice, whether we call it trust or transactions or whatever? The story of medieval courts is they came into being to resolve disputes so that polities, city-states could expand their own sense of their authority. I mean, functioning economies need resolutions of conflicts, as you all know better than we do. So the question is, what's the nature and shape of it, and how can it be interactive with regulation while not being totally an artifact of regulation?
So this is a fabulous discussion, and I would personally like to continue for another hour. I suggest that we find a way to meet over a very large quantity of tea and continue this. But we're going to need to pull this together. So that one of the things which has emerged from this whole discussion, because starting by observing what happened at the American Arbitration Association in a case where I actually think dispute resolution matters. It's very much part of our life. And I started by thinking about dispute resolution as a process. And I looked at trust as something that makes everybody better off, because you know what? We have these class action suits. We have what happened with this one company that we observed, which looks a lot like a prisoner's dilemma. This was really a very nasty set of outcomes for everybody. So if we combine, economic understanding with systems thinking, process thinking, then what we realize is we need for the world to work a lot like what Chris is doing. And the question is, how do we scale that? By the way, one thing which Chris did not mention is that he spends a lot of effort on his website also kind of teaching people how to avoid pitfalls. That if you rent a car these days, these are the things that can go very badly wrong. And here he has standard operating procedures for, here are 15 things that you must do because these $4,000 bills, this could happen to you. So what has emerged over the couple of years that I've been working with this question, and this is why John Gray is here with us today, as Department Editor of Public Policy and Industry Studies, is that I think that this topic shows the potential of operations being brought into the public policy space, linking journalism, access to knowledge, belief in the rule of law, belief in alternative dispute resolution, and good old-fashioned economics. Part of the reason why I was so thrilled, Judith's paper, I'll put a link to it, 70 pages, I sat down and I read it from cover to cover. And because I was like, yes, this is knowledge suppression. And the thing that amazes me, there was a hearing at U.S. Senate committee just a couple of weeks ago that went into mandatory arbitration. And it was absolutely clear that none of the experts knew about this, the fact that 41% of cases are getting a not today, not in the mood. This came to light with a single case following an operations management approach, right back to the old Toyota production system, Gemba, go walk and see what's happening. So I would like to suggest that if we collaborate across our fields, we can break this cone of silence. And I would like to call the field to do it. The second thing is that we are in a position to convince Cliff that we can get people to care about trust, that we can get them excited about it. We need to rethink the payoff matrix. By the way, disputes, back in the early days of the Toyota production system, people were hiding from defects. Now they're hiding from disputes. And we as a field came to learn that defects are a tremendous source of knowledge. Disputes are the best way for these companies to learn. So that if we combine our resources, not trying to scale Chris and make him, big enough for all of us, but if we work together, we can get people learning from disputes and we can engage in systems thinking. With that, thank you so much to everyone for being part of this webinar. We look forward to what happens next.